There's approximately 1,600 community development districts in the state of Florida. I believe this will be the first appellate decision that addresses the taxability of these districts for ad valorem purposes. The Department of Revenue is of the belief that this court must review and analyze this case through the decision of the Florida Supreme Court of Gainesville II, which was the 2005 decision. There's a hierarchy of analysis. First, because the operative statute 189.403 says that you must determine the exemption as if it was taxed as if municipality. It leads us back to Article 7, Section 3A, the municipal exemption. And really there's a two-pronged test. First is it municipal property? I think the statute gets us there, but the next one is the test that's set forth in Gainesville II. And the test from the court was that for municipally owned property, it has to be exclusively used in a manner so the activities are essential to the health, moral, safety, and general welfare of the people within the municipality. Now, the facts in this case relate to a community development district, and this is where certain infrastructure, recreational facilities, retention ponds can be developed without using the traditional government resources of cities and counties. And it's to promote development and actually help sell real estate and commercial development.
Let me ask you about Gainesville, City of Gainesville, because that case has been up and down through this court many, many times.
That's correct. I was here on the last case.
I know you know that.
And it's
you
still
know the
going
facts
on.
of that case. Does the, and you focus, I think, upon the word exclusively in the test that that's the way they've construed the constitutional requirement, I believe.
Correct.
Right? Doesn't that case apply particularly well when a local government is engaging in some sort of traditional commercial activity that the private sector has done, such as telecommunications?
Well, keeping in mind that the City of Gainesville case was primarily involved with the internet and telecom business, but there were also two other categories of property which were at issue. There's the telecom towers, which the panel found in the February 2007 decision that they are taxable, and also the so-called Deerhaven property, which was owned by the city adjacent to their power plant, but which also was used, there was a hunt club lease on it and timber lease. And this court found, and I think that determination governs in large part this case here, the taxability of this type of property. Coming back to your question, I believe.
I want to be sure you see where I'm going. Cities around this state for years and years have operated golf courses, right?
Correct.
As have other non-taxable entities.
But I think under the current test, as enunciated in what we call Gainesville II, the Florida Supreme Court decision, they're taxable. There are also two cases. There's which we cited in our brief, the Capital City Country Club, which is a Florida Supreme Court case, Capital City Country Club v. Tucker, as well as the Concord case out of the second DCA. Both of those cases found that the operation, even under the old test, the more liberal test of Sebring 3 and 4, that the properties are taxable. So I think what we have to look at here is the nature of the businesses and apply the test. And in the most broad sense, what we're saying is looking at the property on the.
So you wouldn't agree with the proposition that traditional municipal type activities such as playgrounds, golf courses, somehow are a little bit different?
Well, they might be different, but in this case, I think there are some important factual distinctions. For example, if this was the only golf course in Clay County, Green Cove Springs, then very well you might be able to find it's essential, but certainly that's not the case. If you had a large park, such as we have Tom Brown Park here in Tallahassee, that's accessible for large numbers of people, you would have that. But in this case, for example, the playgrounds are very neighborhood limited. There's no parking. They're basically, you can walk to them. So on this basis, I'm looking at the manner in which it's, the community as it is, that you must analyze the case. It's not limited, I believe, to the community development district, but I believe the analysis is on a larger, more regional scale. And I think that it is not shown that it's essential to the morals, general welfare, and well-being of the people in that area. and therefore it's just a purely commercial activity like the hotel in the karate case in Orlando that was cited in the brief of the property appraiser. What we have here is a narrowing of the exemption. I think if we had another case here with the city of Tallahassee, the municipal golf course, if it was a new case, it would probably have to be found to be taxable.
What if the city, and you corrected my, you were very diplomatic. I said exclusively, and the word from City of Gainesville is essential, I think, is the right word. What if the city of Tallahassee or any other Florida municipality bought a parking lot on a separate parcel across the street from City Hall, just in order to make it easier for people to get to City Hall? What's the result there?
I would say, go back to the facts and circumstances.
We don't have any parking at our City Hall in Tallahassee. Those are the facts and circumstances.
I know. I think that's an activity that I don't believe it is necessarily essential. You could park down the street, park on the other side of FSU. You might have to walk a few blocks, and I know that's a problem, but we also have...
So DOR under the City of Gainesville is going to take the position that parking lot may well be subject to ad valorem.
Yes, that would be the position of the department, Your Honor. So continuing, if I might, in the brief of the, I'm just trying to watch my time closely. See, I'm getting close. But in the brief of the crossings in this case, basically what they're arguing is that recreational opportunities, citing the obscure Hogan case from the city of Miami Beach, which really didn't have that holding. There's dicta in the city of Gainesville case that deals with the Hogan case. Recreational opportunities in and of themselves do not meet the necessity test that's set forth in the city of Gainesville case. And we relied on, to a large extent, the Cap for Capital case out of the 5th DCA, which I think is very analogous to the situation here. Plus, I think we have the recent decision from this court as to the city of Gainesville. I think the telecom towers, they serve a general public function, and also the Deer Haven property, the same type of general function that we have here with the golf course, the swim centers, and really they're functionally equivalent. As I indicated, under Turner and Capital City Country Club, golf courses have been found to be taxable for ad valorem purposes. And seeing that I'm nearing the end of my time, I'm going to save a minute for rebuttal and turn it over to Mr. Levy. Thank you.
Please, the court. My name is Larry Levy. I'd like to reserve about 4 minutes for rebuttal, please. Our position is that the court erred in all of the properties that they held were exempt. One of them was a golf course, and quite a few others. There was a swim and tennis center, two swim and tennis centers, some playgrounds, Pine Lake playground. Our position is that none of those were, number one, that the statute on which they base their exemption, that you got to treat a city like a community development district like a city, is invalid. And the standing issue was wrongly decided. And number two, these are not essential services under the line of cases dealing with the city of Gainesville recently. With regard to the golf course first, the golf course was never owned by the CDD. The golf course was owned by the developer from the inception, Champion Realty. They started out how they were going to do it. They're going to create a joint venture. You had East West Company out of Virginia, and then they created East West of Jacksonville out of Florida. So you had a general partner, limited partner. They started the development, then they brought in another one, Northeast, I think was the name of it. Point is, you had a common thread all the way. One, owning the land was put into the development then built the golf course. The developer managed the golf course for a long time. I don't remember now, if it's 8 or 9 years, a long time, and then decided we want to sell it. So they had some inquiries about selling it and talked to the district. The district said, well, maybe we can buy it. So they arranged for the financing of it to be paid from the fees of the operation of the golf course. That's how the golf course was to be paid for. But all they had was legal title. The developer had a management company. They continued to manage the golf course exactly the same way. They were paid $180,000 a year to manage it. And that's what they were doing with the golf course. There was an arrangement where the district would agree, this is the fees, this is how much we need to run the golf course. They competed with the private golf courses of other I'll say developments throughout the county and the area for tournaments and whatever, PGA tournaments and whatever. All that is admitted. They had, as an adjunct to the golf course, they had a liquor license, they had a bar, they had a restaurant, they had a golf shop, all of which we feel is subject to tax. The effect of it is very similar, we feel, to what was in the City of Orlando case down in Orange County a few years ago, where the city had a management company that managed the Hyatt Regency out at the airport.
Let me ask you about the management company here today. Is there evidence of the financial arrangement that carried over between them and the city that they, in other words, is it a flat monthly fee or is it a percentage of gross? How does that work?
Is that in Orlando you're talking about?
I'm talking about in this case.
In this case, is there evidence now what?
Whether there's evidence in the record to show that the management company's contract is tied to gross revenue or whether it's some sort of flat monthly.
Management. They had a contract. They were paid so much, $180,000. If there wasn't enough money coming in to pay it, the budget was based on that, then they would not be paid, but it carried over and accrued to the next
They
year.
had an annual contractual amount.
Annual contractual arrangement where they operated it like that with the CDD. The CDD had no employees for the operation of that. They also had a management company that managed the bar, managed the restaurant, managed the swim centers, managed everything was through the management company, which had been an adjunct created by the developer originally, Champion Paper, back through the various limited partnerships I'm talking about.
Mr. Levy, the bar, the restaurant, and the pro shop did not get an exemption. Is that
No,
right?
sir, they didn't. He held those taxable. They were the things that were part of the CDD to begin with were the swim centers. I think there were three, the southern and the northern swim centers, and there were some area little parks that they had in there. The swim center had an arrangement where the people that lived in the district got little fun cards as part of they paid special assessments or maintenance fees on them. And if you did not if you did not live in the district, there were 7 people that did not live in the district that paid $1,800 a year to do that. Insofar as the operation of the golf course, and then they could use the swim center, those 7. Otherwise, it was solely within the district. With regard to the golf course, you had certain fees. You could have patron fees. Somebody could become a member and a patron. They use the term patron, not member. But it did the same thing. This gives you a membership here, and you have certain privileges with regard to advantageous times. But non-residents and residents could use it. All the testimony was undisputed. They compete with any other golf course in the county. They're trying to get tournaments. They do exactly the same thing as the others do. And it's done by the management company. The contract was for 9.5 years, I believe, for that time period. And then at that time, they either renegotiate or do something different. I think it's really pretty clear that under the rationale of what is essential, you have 2 problems. One, the management fee, management arrangement is similar to what we had down in what was there in the City of Orlando. May not be a precise lease, but it's certainly the same type thing where control is vested in somebody else. They have the CDD had no employees. Management ran everything. So control is gone. They're running it. Now, what are they doing? They're a profit-making venture. So we would feel like under the prong of governmental versus governmental proprietary, that would certainly be, although it's technically a lease, it's a management company. They've divested themselves for the period of that contract, which is almost 10 years. Somebody else is going to run it. And
Well, are you arguing equitable ownership on behalf of the management company? You're not arguing that, right?
No, we're not. No. Nothing like that. It just terminates at the end of it. Then would wind up being either they would bail out or get renegotiated. The testimony was that they put out bids or feelers to see if some private entity would like to come in and buy it, and didn't get any. And then the district, oh, well, that'd be fine. We'll do it for our golf membership. And that's how that came about. But you follow the rain right all through. And one of the cases I cited is a Frontier case. And it says very clearly CDDs are not governmental entities. And with regard to the constitutional issue, we feel like Lewis, other cases that have held public bodies, public, property appraisers can raise it, defense raise the validity of the statute. Defense.
What is the property?
Sorry?
I ask this question seriously. Why does the property appraiser care whether this property is exempt or not?
That's a job.
Well, his job is to assess the value of taxable property.
And administer exemptions.
And shouldn't we presume that when the legislature creates these community development districts, that they do it well knowing that that is going to reduce perhaps the available pot of revenue to local governments. Why shouldn't we just respect that?
Well, property appraisers have one charge. They're supposed, two charges really: appraise all property at just value, number one, willing buyer, willing seller, and two, administer exemptions permitted by the Constitution, just like in Sebring Raceway. You have the
But
same.
this is an exemption permitted by the Constitution. The CDD exemption is permitted by the statute anyway.
There was in effect an exemption in Sebring Raceway also, because the effect of it is you don't tax the raceway. That was done a little backhanded way. We're going to do it. We're going to call all these Yankee stadiums and everything that down here and all over the state, if you got permanent seating, we're going to call that a governmental purpose.
I guess what I'm saying is this may be a bad deal for local government. It may not be a bad deal for local government. I don't really know, and that's beyond the scope of this record, but shouldn't we presume, and shouldn't the appraiser presume, that the legislature knew what it was doing when it sort of decreased the available parcels for taxation?
Now, let me answer your question like this. In the Highlands County case, the property appraiser has just been to the Supreme Court on the precise issue, and while it is pending, the legislature passes the amendment to 196-0126, I think it was, and comes right back, and now they say, now we're going to exempt this, that the Supreme Court just got through saying ain't governmental. So what are you going to do? You got to take a stand someplace. We have here a situation where amendments were proposed to the Constitution which would have exempted special districts. All of them did not pass. You can't very well look the other way all the time. You're going to have to come in and take a stand. And the Highlands County appraiser, by the way, had the circuit court case. I know it's not controlling here, but I did cite it, and I think I sent a copy of it here, where it held that statute unconstitutional, and the district's first appeal and dropped it.
Is there a problem here that if the appraiser doesn't have standing, there might not be anybody, or could there be taxpayer standing here?
Wouldn't be anybody as a practical matter. The county, the concepts, they talk about public funds. The people are going to get the money are the county and the cities and of course, the school boards. The way that it's set up since '67, only all of that flows through the property appraiser. Nobody else could do it. I cited a case, the Horn case, in the brief that was talking about the difference in appropriation and expenditure. It says it's a difference without, it's a distinction without a difference. Either way, you can certainly challenge the validity of the statute. I think it's under either prong, but as a practical matter, nobody else is going to. How does anybody know? They don't know what's exempted. They don't know what the neighbors is getting. Nobody else going to come in and do it. And what would they do? File a lawsuit against the property appraiser to say, I want to compel you to tax this? And he said, I agree. I think I ought to tax it too. With regard to everything, the golf course, I think, is a glaring example. All of these are operated by a management company, oversaw by the management company, who was an adjunct all the way through the line of the developer, starting with Champion Realty, came up with the idea, how are we going to finance it? Let's finance it with CDD. And that was the way it was done. There's some 600 CDDs in the state.
The department seems to be saying after the Gainesville case of the Florida Supreme Court that something like a golf course can no longer be for a public purpose. Do you agree with that?
Not always. No, sir, I don't. For instance, if you're going to have a golf course out here that's operated in a pure proprietary capacity and competition, they have different animals. Tallahassee's, of course, was a private club leased out, but anybody could belong to it. But it had a lease. That's the one in Capital City. I think it was $1, but it had the lease. It depends on how they're used. I think Gainesville suggests that. It says if it's going to be municipal, it's got to be for the constitutional exemption to apply. It must be exclusive. Very clear on that, I think. And then you have, well, maybe what if it's not quite exclusive? Some of the cases, I cite them in the brief. They're cited in the most recent, I guess that'd be City of Gainesville 3, parking places adjunct to the courthouse. Mentioned, that'd be okay. It says something's got to be very, very incidental.
Well, this was a line of questioning I was going on with Mr. Bukowski, and I don't want to blur the distinction between the state and your client. I don't want to get you in an area where you're don't even have a dog, but it just occurs to me, some cities may choose to build, the town of Palm Beach may choose to build a grandiose city hall with all kinds of expensive paintings in it. Well, that's not essential to the operation of a municipal government, yet you wouldn't take the position that City Hall is not an essential part of government, no matter what it looks like.
No, sir, I wouldn't. True. And there's a lot of things that are done as an adjunct to the overall operation of what's going on that are considered, the cases say, way back to the Walden case cited, that's just an incidental thing. If I have any time left, I'd like to reserve it.
Well, you just ran out. Well, maybe, would we took ask a few questions, would the panel agree to give them, say, 4 minutes, and we'll add that much to your time? We just have 2 cases today. We got a pretty big audience out there, so they might want to hear a little more.
Good afternoon. I'm Don Lester. I'm co-counsel for the Appalachia, the Crossings Taxing District. We refer to it as the district. At the table with me is Rob Bradley, who is trial counsel. Since counsel for the department and the court seem to have some questions about Gainesville 2, I'd like to go ahead and focus on that right away if I could. And I think it's interesting that 2 sides to a piece of litigation could have such fundamentally different views of what Gainesville 2 did and did not do. I think it's important to point out to the court, though you may be quite familiar with it, but if you'll bear with me, I'd like to point out the posture, the procedural posture of that case and why the court, I believe, ruled the way that it did. The city of Gainesville made a facially unconstitutional challenge, unconstitutional on its face, of a statute enacted by the legislature which stripped the municipality of an exemption it would have otherwise had pursuant to statute for operating the telecommunications business. And when faced with, or when presented with, an unconstitutional on its face argument, the Supreme Court could not get into whether there might be circumstances where a telecommunications business could or could not be essential to public services. The court actually issued a very narrow ruling, and if I might quote, if you'll bear with me, I'd like to read this.
Tell me what page you're reading from.
I'm sorry, Judge. It is on page 253. We make the narrower determination that in providing these services, regardless of circumstances such as the availability of the same services through other providers, a municipality does not, as a matter of law, engage in an activity essential to the welfare of the community. That was because just earlier they had said, we conclude that providing these services does not, as a matter of law, again because we're dealing with an unconstitutional on its face argument, always serve municipal or public purposes. So, again, if they had been faced with an as applied, and they go on later in the opinion to talk about that, they could have looked at and they could have analyzed whether this particular statute or this particular use constitutes an essential public service. So in the face of a facial challenge in the city of Gainesville, the fact that, say, hypothetically, they were using some of these hookups for fire and police protection, that didn't make any difference. That's right. That's not the test, because the court is saying, is there any circumstance that would support the legislative action? Exactly. The court then goes on to, as you all know, I'm sure, with a detailed analysis of the 1885 Constitution and the 1968. And I thought it was very interesting that the court pointed out that even though there was a change and Article 7, Section 3 became self-executing, and therefore the court did not need to show deference to legislative determinations of public purpose, the court did go on to say that there is nothing in the language of Article 7, Section 3 that evinces an intent to either create a broader or a more restrictive definition of public purpose or municipal or public purpose for property that is owned and used exclusively by the municipality. Now, I read Gainesville 2 to say all we're doing is going back to the essential core analysis. Nothing has changed in what does or does not constitute an essential or core public purpose. I've heard the argument also made regarding the term exclusively, and I believe, Judge Kahn, you may have had a question about that, or I think it was the term essential.
I think I misspoke.
That's right. I'm sorry.
Essential is the word.
But they did, the appellants did make the argument regarding exclusive. And again, I think they misread Gainesville 2 on what exclusive means. Is it exclusively by the government entity, or does exclusive apply to the use? And the way I read Gainesville 2, exclusive applies to the use. That is, it's not improper for a governmental entity to enter into a management contract in order to operate something in a better fashion than the government entity can do it. And in fact, One of the cases that was cited by Mr. Levy, I thought was very telling. It was the Sebring against Airport Authority case. And if the court recalls, that dealt with a distinction between public purposes for bond validation purposes as opposed to ad valorem taxation, and the court, of course, drawing that distinction. But I found something very interesting in that case, which they quote Article 7, Section 10, dealing with bonds, and the Constitution says that if there's any project financed with bonds occupied or operated by a private corporation pursuant to a contract or lease with the issuing body, it's subject to taxation. Now, Article 7, Section 3 does not contain that language. So as a matter of statutory construction, it is proper for a government entity to enter into a management contract to operate this, because if the legislature or the framers of the Constitution had wanted to make that exception, they could have done so, as they did in Article 7, Section 10. Finally, as to Gainesville 2, the court went on to affirm all of its previous rulings regarding what does constitute an essential government or municipal purpose for purposes of ad valorem tax exemption. They mentioned housing, they mentioned light, heat, and power, they mentioned vacant land held for future use, parks, and so forth, as being consistent with the traditional municipal function. Still on my time? Okay. My point being here is they go on to say electrical parks, public parks, and so forth are traditional government functions, and therefore there's nothing that I read in Gainesville 2 to demonstrate that they're receding or creating a stricter test for purposes of finding an essential public purpose. Now, in our case, as has been pointed out, only two areas or two parts of the operation were found by the trial court to be an essential public function: the golf course and the swim and tennis center. After weighing all the evidence, the trial court made the determination based on Gainesville 2 and the other cases cited that those constituted traditional functions or public purposes that governments are normally involved in order to provide recreation for the health and welfare of its citizens.
Well, if I may, let me move you to the standing argument.
Yes, sir. I'll be happy to discuss that.
Why isn't the property appraiser in this instance exactly in the defensive posture that the Supreme Court has talked about, like in the Robbins case in 2002 case?
Judge, I believe that the Sun in the Lake case is actually the one that is directly on point. And that was cited by Mr. Bradley at the trial court level in support of his motion to strike. In that case, the appellate court held, and it was very similar. It was a community district, a special taxing district just such as this, and the property appraiser refused to...
You talking about the second DCA case?
Yes, sir.
Well, okay, that's the second DCA case. I'm
Right.
talking about the Florida Supreme Court has held, or they've at least said, and, you know, I guess we can... Justice Bell, more recently in the 2005 case, said that that's dictum, and, you know, I won't
Right.
quarrel with that.
Right.
And he says that the language in the majority earlier opinions saying that you can bring this defensive posture is not a good idea, but that's a concurring opinion. So
Right.
in the Florida Supreme Court precedent, there's language saying that the appraiser can bring a defensive posture. Isn't the appraiser in a defensive posture in this case?
Judge, I think the distinction is if you look at the factual circumstances that led to that case, and I do agree that I think it's dictum and not central to the holding of the case, I don't think you had a situation where the property appraiser manufactured a situation so that he could be put into a defensive posture. I don't think that was the fact situation in that case. And I believe that's what troubled the court in Sun and Lake, and that is, you know, it's settled law. We all agree it's black letter law that defensively they can raise that. Now, the issue
what
is,
I'm struggling with is Justice Bell kind of, you know, he says maybe this doesn't make any sense to have, you know, the appraiser why would they be allowed to do this in a defensive posture just by denying the exemption if they can't do it in an offensive posture? And I see that argument, but at the same time, I see the language that's pretty explicit in these other Supreme Court cases. How do you deal with that?
Judge, I think I just have to say that I don't think those were the holdings, those languages constituted the holdings in those cases. I can see that one should take note, and perhaps one could be persuaded, but it would be our position that we don't think that was a holding in that case constituting precedential value.
Would you agree, regardless of whether you agree whether a defensive posture case should be permitted or not, would you agree at least procedurally here that the appraiser is in a defensive posture?
He's in a defensive posture because he forced the district to bring the action,
Okay.
as in Sun and Lake.
Now, if we assume that the appraiser has standing and can bring the constitutional challenge,
Right.
do you concede that this statute is unconstitutional?
I do not.
Why not?
Well, I guess, Judge, I probably didn't come terribly prepared to argue the constitutionality argument because since the trial court did not treat with that, I can't honestly say that I did that much in that regard. I guess what I would say is, going back to...
So you're saying that's an issue if we decide the appraiser has standing, we ought not to reach that issue?
Exactly, because the trial court never had an opportunity to consider that issue. The trial court could go either way, I suppose, but that issue has not been dealt with in this case, and I don't think it's properly before this court. But I guess it just is one additional, maybe partial response. I think if you go to the considerations that were expressed in the Gainesville 2 case regarding deference to the legislative intent. There was a comment from Judge Kahn before about, should we be going back and second-guessing that? I believe that the argument could be made that the legislature, in allowing its discretion or its determination to which deference should be given, that this is an appropriate public policy in order to shift the cost, for example, of building this infrastructure. Is it for the courts to go back and second-guess the legislature on what's the best public policy in order to foster controlled and manageable development? And I guess that's probably about the best I could respond to that.
Judge Polson, I've got one question on sort of a follow-up to you now. I'm familiar with this case of Sebring Airport Authority versus McIntyre.
Yes, sir.
And the appraiser there challenged the constitutionality of the statute.
Right.
And the Supreme Court affirmed a lower court ruling that it was unconstitutional, didn't it? So doesn't that pretty well defeat your argument that it was dictum or not necessary to the disposition of that case that Judge Polson mentioned? But it certainly was here because the property appraiser, in a defensive posture, challenged the constitutionality of that statute and prevailed at the Supreme Court level. That seems to me like that pretty well says if they're in a defensive posture, they can challenge the constitutionality of an exemption statute or whatever in the tax area. How do you respond to that?
I think I would respond to that, Judge, by saying that no one in that case raised the issue. That issue was not before the court. Now, I guess an argument can be made that sub silentio, it approved the property appraiser raising that, but by treating and handling the case and rendering an opinion. But that issue was never raised to my
Well, the counter argument to that is that the principle of law may be so well settled that they didn't want to argue that in that case. I mean, don't you figure that the counsel against the Florida Supreme Court knows the law in this area pretty well, and if they thought there was any validity in that argument that they would have raised it?
Well, there were other cases, though. For example, the Turner case, where I think the court reaffirmed the proposition that, the property appraiser, of course, can't be in a plaintiff's position or, and I think under the facts of the Turner case, I think stuck with the position that, yes, you have to be defensive. And I don't think the issue came up in that case either as to whether the actions of the property appraiser triggered or forced the taxpayer into filing the action. I just don't think it was in that case. At any rate, just in brief summary, I think there's been a concession that for purposes of the two-pronged test in Gainesville, we do have the municipal property. I think that the trial court, after consideration of all the evidence, made a determination that some of those were essential, some were not.
But that's not a factual determination. It sounds like it is, but it really isn't, is it?
Well,
Don't we get de novo review of that?
based on the way that I read that Horatio Enterprises case, I still think it involves weighing the various factors that were adduced by mostly the plaintiff. There wasn't much evidence that was adduced in the defense part of the case. And evaluating that, weighing that, he made the determination, okay, based on this case law, I think these fit within what has traditionally been considered. These don't. Quite frankly, we chose not to cross-appeal that because we thought, based on the standard of review, that was just not going to be a good idea. We didn't think that we had much of a chance on that. And in the Horatio Enterprises case, I think it's well settled that it's really not for this court, with all due respect, to say, if, after weighing the same evidence, that you would have reached a contrary result. I think the only standard in that case is there no evidence in the record that supports the trial court's determination? Now, y'all could, of course, still reach that conclusion. But as far as the trial court's weighing of the facts that were reduced in the case, I don't think this court should redo that. And I see that I'm out of time.
Well, wait a minute, I don't think you got your additional time added on that we gave the opposing side. So I believe you're entitled to 9 additional minutes. And am I correct?
I don't think it would be 9.
We gave
okay.
opposing side, I believe, 9 additional minutes, did we not? So they should be entitled to the same amount. So let's add 9 minutes there. You don't have to take it.
All right, believe me, I won't. Believe me, I won't. Get a little thirsty as it is. Okay, we talked about the standing issue. One thing I do want to point out to the court, because I think, based on opinions that I've read and the experience I've had before appellate courts, I don't think courts are anxious to reverse trial courts on grounds that the trial court did not have an opportunity to consider or that were not advanced. I want to candidly concede we did not raise this in our answer brief, but when I was going back through the transcript of the hearing on the motion to strike, I did not see that the trial court was given the benefit of the public funds argument at that hearing. It was strictly on the defensive posture, and I do just want to point that out since there was some argument about that in the initial brief.
I guess I'm a little confused about the standard of review after looking back at the briefs. Summary judgment case, normally that's de novo, but I guess I was thinking, and maybe I'm wrong, that the appellate court would kind of take its own look at this whole municipal purposes thing. But help me out with that just a little bit more.
Well, I guess what I would say is, of course, you could look at the same evidence.
Well, you want to argue for deference to the trial court.
Oh, clearly.
But it's a summary judgment matter.
Well, this was after a full trial.
Full trial, okay.
Right,
trial.
right, with cross-examination and so forth. And so, yeah, if we were here on summary judgment, I think I'd be speaking, I'd definitely take a different position with you. But, you know, the court sitting as the finder of fact in a non-jury trial, I just believe, you know, based on the cases that we cited for the standard review.
I guess the question really is finder of fact on, say, whether the golf course revenues were $1 million a year or $1.5 million, we'd have to defer to the court. But on the ultimate question, that's...
Well, yeah, but I think that under the Horatio case, it all goes to also reweighing the totality of the evidence. Now, again, I concede that as a matter of law, y'all could look at that same evidence and say, there's under no resolution of these facts does that constitute an essential public purpose, and then reverse the trial court. I think you could do that. No question about that.
And that'd be a de novo review of that application, right?
That would essentially be that standard. That's correct. That's exactly right. Which obviously we don't concede that is the standard, but yeah, I would definitely concede that point. But I think it is important to note there's a lot that I think has been said, somewhat candidly in response to questions from the bench, that's not in the record of this case. It has to do with what else is out there in Clay County, what other people do or do not do. But I think it is important to stress that there's no question that the district is properly constituted. Nobody's making any of those arguments. And number two, that it is not a profit-making enterprise. Most of the cases relied upon by the appellants to try to bring this case outside of proper tax exemption, deal with leases, they deal with for-profit enterprises, for example, the Orlando Crotty case. The court specifically said this is a hotel for profit that's been leased to a profit-making entity for the benefit of citizens outside of Orlando. By its nature, it's a hotel. That's why it's not tax exempt. Sebring, again, lease, for-profit. You can't do that. In this particular case, we don't have a lease. The testimony was undisputed from the district chairman, or actually he was the vice chairman at the time of the trial, that they consciously set their budget so that it is a break-even proposition. It is not a for-profit entity. So we don't have the lease. We don't have the for-profit entity, and it clearly provides for a function that governments normally do provide. Golf courses, swim. This court could probably take judicial notice of that. So at any rate, I'd be happy to respond to any other questions the court might have, but I don't want to take up too much more time. All right, thank you.
I just have a couple points, Judge, and I'll be concluding in a minute. Two things. First, I want to address Judge Kahn's comment. This is not an automatic exemption, and I want to make sure that the court is aware of that. Under the municipal exemption of Article 7, Section 3A, it is not automatic. Whether you have to meet the test prior to Gainesville 2 or the current test, it still has to be met. And I don't believe that the Community Development District has shown, and the evidence in this case shows, that it is essential. Things that are essential are as what was noted by the Supreme Court. Municipal electric power plants, public housing, not golf, not swimming pools. If there's any question as to the test of Gainesville 2 being narrowed, I would commend this court to the dissenting opinion of Justice Onstad in the Gainesville 2 decision. He made the following observations. It would also appear that the majority opinion is engaged in a flawed analysis to now radically limit the scope of municipal purpose. And then continuing down. In fact, with the majority's new and restrictive definition of municipal purpose, one is left to wonder what will happen to all of the services that municipalities now provide, including municipal parks, pools, zoos, and a multitude of other services that have previously withstood court challenges.
Yeah, but you're reading from a dissenting opinion, right?
Well, he's commenting on what the majority did. What I'm saying is I think it's undisputed, as was argued in the Gainesville case and as I argued last September in the Gainesville 3 case that was just decided by a panel here in February. There was a very significant narrowing of what's exempt under the municipal exemption statute, Section 3A, in the Constitution. And then finally...
But you do concede, though, counsel's point, that the city of Gainesville did not involve a challenge by a taxpayer to individual assessments. It involved a facial challenge to a statute.
The second case, though, which was just decided in February, that was the as-applied challenge.
Right.
And there are motions for rehearing en banc. I think my reply is due in another week. But out of everyone here, I'm the only one who's worked on those cases.
Well, we're talking about I assume we're talking about the 2005 Florida Supreme Court.
Yes, that's what we call
Gainesville
Gainesville 2, correct.
2, and that had to do with the facial validity of a statute, not with picking at individual assessments and applying the public purpose. All they had to do in that case was look at the statute. I mean, I can't phrase it as well as counsel did, but if it's constitutional in any application, then it's not facially unconstitutional.
They narrowed the definition.
Well, there's a dispute about that in this courtroom.
Well, okay, and I respectfully suggest to this court that it is. And finally, all I can say is with respect to the standing issue, I know standing is very important. We had it in the Wicken case a couple of years ago. But in this case, it's the position of the Office of Attorney General that constitutional officers cannot be saying statutes are unconstitutional. I think the concurring opinion that was referred to of Justice Bell in the Sun and Lake case, it was Sun and Lake, whatever it was that we cited in our brief, that pretty much articulates what I believe is the correct position, and that's the position of our office.
Okay, a municipality may do that, is that right?
Municipality, sure.
They do it all the time.
They're not a constitutional officer. The property appraiser is. I mean, I have my personal opinions, but I'm here representing the state. The state believes it, and also I think there's also law that if you don't have to reach the constitutionality of the statute, you can decide it without getting there. That's also appropriate. But I think, the city of Gainesville properly was raising it, but the statute was found to be constitutional. And I'm just making this observation on behalf of the Attorney General, because this is what we seem to be a recurring problem that we would like to end. Thank you.
Mr. Levy, you got 46 seconds and you walk fast.
46 seconds.
That's what opposing counsel left you. You'll have to.
Thank you. With regard first to parking and some things like that cities do, cities have parking meters, and those courts have been, that question has been tested through the courts, and that's a regulatory measure under the police power. Much of the parks, what they do, that's also regulatory. Many times they'll charge an incidental fee. If you've got two kids playing in a little league, you pay $5 or $6 or something, and that's a regulatory nature. Tennis courts the same way. So if you only got so many, you regulate the use of them. Golf courses, cities can do the same thing. Of course, cities can have golf courses if they want to. Might be some situations where they decide they're going to go into a proprietary activity of competing with the PGA or something. That might be a different animal. With regard to the use of the property, the golf course, it's a good deal for the developer. They pay him $6-point-something million and then $180,000 a year for 9 or 10 years, and maybe he stays on if he wants to. That's pure proprietary use of the golf course under any stretch of the imagination. The recent case here in February dealt with the situation.
Sum it up quick, Mr. Levy, because I'm going to give you one more minute, and then we're going to cut.
Do I get to finish this last thought?
Yes, sir, in that minute.
Yes, okay. The most recent City of Gainesville case, you had Deer Haven property was one of the issues, wholly purchased by the city, subject to a timber lease and a hunting lease that was retained. This court said, no, wait a minute now, that's not exclusively. They're still going to be marketing the timber off of it at some juncture in the future. The contract provided that the city could step in and be first refusal on it or something. But I like that. You have regulatory measures insofar as use of property, and have always had those, and those are valid under the police power. Here you're dealing with a different animal, and we are dealing, I think there was a substantial change. When they inserted the word essential, they made it clear you can't use public bonding test to apply to tax matters.
And your time is up.
Thank you.
Thank you. Thank you. While we're clearing the well